to hear from the appellant.
May it please the court, I'm Tom Seeley from the Washington County Bar. And I had the privilege of representing Penny Lawson, the widow of Stephen Lawson, Corey Lawson, the son of Stephen Lawson. And I'd like to ask that I have 3 minutes reserved for rebuttal.
That'll be fine.
February 16, 2023, the Tennessee Supreme Court filed its opinion in Lawson versus Hawkins County and remanded this matter back to this court for further proceedings consistent with its opinion. This court then identified 4 issues that we're here today on. First issue is whether the plaintiffs sufficiently preserved and presented arguments that they alleged ordinary negligence in addition to gross negligence and recklessness. Also, whether TCA 786-320 and TCA 292108 removes immunity for certain claims against the Emergency Communications District 911. If those arguments were sufficiently preserved and presented, and whether plaintiffs' complaints sufficiently alleged ordinary negligence is the second issue before this court. And also then the third issue is whether TCA 786-320 and 292108 remove immunity for certain claims against the 911. The fourth issue then is whether the public duty doctrine independently bars any of plaintiffs' claims that may proceed under applicable statutory law. And just briefly, the facts of this case, that on the early morning of February 26, 2019, a mudslide washed away both lanes of Highway 70 on Clinch Mountain in Hawkins County, Tennessee. A driver that was traveling north on Highway 70 called the Hawkins County Emergency Communications District at 12:58 a.m. They reported that trees were blocking the road and that the highway was cut off and that a driver going up the mountain would go off the road. A Hawkins County deputy was dispatched to the scene about 5 minutes later and arrived at 1:13 a.m. At the scene, the deputy called 911 and advised that they should contact the highway department to report a big mudslide and a leaning power pole. Although the dispatcher expressed some concern that one of these days the whole mountain is going to come down, neither the dispatcher nor the deputy discussed closing Highway 70. Instead, the dispatcher joked and warned the deputy not to let a rock fall on him. At 1:46 a.m., the deputy called 911 again. This time he reported that a car traveling south on Highway 70 had hit a rock embankment and flipped down the mountain. The driver of that car was Stephen Lawson. Both lanes of Highway 70 had completely washed away. And Mr. Lawson was trapped in his car for approximately 11 hours and died before help arrived. Shortly after 1:46 a.m., the deputy also told the dispatcher that a second vehicle traveling south on Highway 70 had rolled down the mountain. Then the deputy advised 911 that we should ask neighboring Hancock County to block the road. The Hawkins County EMA director, whom the dispatcher had called earlier that morning, did not arrive at the scene until after 3 a.m. The first issue before this court is have we preserved and presented arguments regarding TCA 292108 and TCA 786-320. And clearly in our brief, in the initial appeal to this court, the second issue that we set out was that the trial court erred in holding that the GTLA precludes recovery against Hawkins County Emergency Communications District for injuries proximately caused by grossly negligent or reckless conduct by district personnel, despite specific provisions allowing those claims under Tennessee Code Annotated 292108 and TCA 786-320. So clearly that issue was preserved and was argued before this court. And in our brief to the Supreme Court on pages 15 and 16, we set out in that brief, the GTLA also removes immunity under TCA 292108 in cases of gross negligence or willful misconduct, and the complaint asserts claims against ECD 911 for negligent and grossly negligent conduct as noted by the trial court and the Court of Appeals. Also in the brief to the Supreme Court, we argued, and this is quoting from our brief, the complaint also relied upon TCA section 786-320D1, the code section that establishes emergency communication district boards, which removes immunity for emergency communication districts for claims for recklessness or intentional misconduct in processing emergency calls. So we have presented and preserved arguments on both of those statutes. Regarding the preservation of the negligence claim, and again, that's a little bit of an interesting issue there because the trial court specifically in his opinion did state that the complaint certainly asserts negligence claims. This court on appeal also referenced the trial court's holding and stated in its opinion that the trial court held that plaintiff's claims of simple negligence removed defendant's immunity at least before the application of the public duty doctrine. So again, that's not been an issue regarding asserting a negligence claim because it was clear in the complaint, and that really brings us into issue number 2. Did the complaint sufficiently allege ordinary negligence? And clearly that is what the trial court held and what this court had referenced. I would point out again regarding issue number 2, did our complaint sufficiently allege ordinary negligence? Paragraph 27 of our complaint states, all defendants were on notice and consciously aware that Highway 70 had an active mudslide, severe road hazard, trees in the roads, and a power pole. It was destabilized due to the mudslide for almost an hour before any attempt whatsoever was made to close Highway 70. Paragraph 29 of our complaint states, despite being aware of the substantial and unjustifiable risks that any vehicle traveling southbound on Highway 70 at Clinch Mountain would undoubtedly travel directly into the gaping void left by the complete destruction of the road, the defendants failed to act in any meaningful way that would have protected motorists. And paragraph 3 is important in this complaint because it alleges with regard to all defendants ordinary negligence of their employees, officers, and agents in a failure to adequately train employees regarding proper protocol and procedures. Also, failure to maintain adequate or proper protocols or procedures and proper licensing under state law and regulations. So that paragraph of our complaint alleged negligence against all defendants for failure to train. Paragraph 34 of our complaint states that immunity for all defendants has been removed for this action pursuant to the provisions of TCA Section 29-2203, 205, and 108, and said negligence constitutes negligence per se under these and other relevant statutes. So clearly with regard to issue 2, our complaint contains allegations of ordinary negligence. With regard to issue number 3, dealing with TCA sections 786-320 and 2920-108, immunity is removed for certain claims against ECD 911. 2920-108B specifically waives immunity for 911 and its employees where the employees fail to attain and maintain training requirements as required by state law. And as I pointed out, our complaint specifically asserted that allegation. TCA 2920-108E waives immunity in cases of gross negligence or willful misconduct. In our complaint, we allege 911 was grossly negligent in their failure to close Highway 70 in paragraph 30 of our complaint. TCA 786-320D1, which is the statute that creates, that title creates the Emergency Communication District, expressly provides that immunity for emergency communication districts is removed for claims for recklessness or intentional misconduct in processing emergency calls. So 911's immunity has been expressly waived by the General Assembly both in the GTLA and Title VII of the Tennessee Code. With regard to then issue number 4, the public duty doctrine, and it does not independently bar any of the Lawson's claims since the third special duty exception to the public duty doctrine does apply and we have asserted reckless conduct. So again, the immunity of the Emergency Communication District has been removed under the GTLA, under 2920-108B and E. It's also, their immunity's been removed under Title VII. Then, again, we've asserted recklessness, which removes their immunity under the public duty doctrine. So, with regard to issue number 4, it's clear that we have threaded the needle and been able, especially with the Emergency Communication District, to remove immunity under the GTLA and Title VII and the public duty doctrine.
What is to the other defendants?
What I would argue there, Your Honor, is we have asserted negligence with regard to Hawkins County, both the EMA and the Sheriff's Department, in the negligent failure to train in paragraph 33. That removes their immunity under the GTLA. Then we have asserted that the conduct of the deputy in taking no action to close the road is reckless conduct, and thereby removing their immunity under the public duty doctrine with the third special duty exception. So again, we have threaded the needle with regard to Hawkins County too. We have removed their immunity under the GTLA with the negligent claim for failure to train their employees, which resulted in the reckless conduct of their deputy in taking no action to close Highway 70. And again, I think that was the issue that we came before this court when we had, at the trial court, when he ruled that certainly we had asserted negligence claims, but that could not get past the public duty doctrine, and that our reckless claims could not get past the GTLA. And
so it's your position that the exception, the public duty doctrine, number 3, is applicable because you alleged recklessness, but the claim you're proceeding on against, and I'm talking about the other defendants now, not DCD 911, is based upon allegations of negligence. So you get the immunity removed because the allegation is negligence, and then the third exception to the public duty doctrine doesn't apply because it was reckless.
Yes, Your Honor. Based on the Supreme Court's ruling, I think that is what we are left with. And again, I think that illustrates the problem that we're faced with when we have this juxtaposition between the public duty doctrine, the common law, and the statutory law. But I think that is correct. We have removed the immunity of Hawkins County based on the assertion that they negligently failed to train their employees, and that resulted in the reckless conduct of the deputy, and that then removes the immunity under the public duty doctrine. So again, I think that allows us to travel forward against Hawkins County. And again, at this stage in the pleadings, all of our assertions should be taken as true. Again, if that does not play out, we will have to deal with that at the trial court level. But again, that has been asserted.
Thank you. You have your time for rebuttal. We'll hear from the appellees.
May it please the court, I am Russell Adkins of the Sullivan County Bar, and I'm here on behalf of the Hawkins County Emergency Communications District. I would like to reserve 5 minutes of the appellee's time for Mr. Ward.
All right, so you'll take 10, we'll take 5.
Counsel for the appellants is correct. Mr. Seeley has stated correctly that this case really involves the interaction, the interplay between the public duty doctrine and the doctrine of governmental, under the statute under the Governmental Tort Liability Act. The public duty doctrine bars all claims except those based on reckless misconduct, and governmental entities such as 911 are immune against claims of reckless misconduct. Plaintiff must allege a claim that survives both the public duty doctrine and the Governmental Tort Liability Act. The trial court found that the plaintiffs have not done so, and we urge that that ruling be affirmed. Plaintiff alleges 2 statutory causes of action against 911. The first is Tennessee Code Annotated Section 2920-108. And the Supreme Court addressed that statute in its opinion and pointed out that the statute applies a gross negligence standard if the dispatchers had attained and maintained certain training requirements. Otherwise, they would be subject, the Emergency Communications District would be subject to suit for ordinary negligence under Section 205. Those facts have not yet been developed, so the standard could be either ordinary negligence or gross negligence, depending upon the proof. Either way, that claim must fail under the public duty doctrine because gross negligence does not create a special duty. Only reckless misconduct creates a special duty. So it's our position that only claims for recklessness and intentional misconduct would create a special duty under the public duty doctrine, So a gross negligence claim would not be permitted under the public duty
So
doctrine.
you say there's a difference between a gross negligence claim and reckless claim?
I would, Your Honor. I think the Supreme Court addressed that in its opinion that it is a different, it's a different standard and it's a different level of conduct. The second statute that plaintiff relies upon is Tennessee Code Annotated, Section 786-320. And that statute is not part of the statutory scheme that creates governmental immunity. It is part of a statute that creates a new statutory immunity for entities involved in the use of internet protocol dispatching, which, as I understand it, involves phone calls that are made over broadband internet connection instead of analog phone lines. That statute creates immunity for, quote, processing emergency calls, close quote. The immunity provided in that statute is removed in cases of recklessness or intentional misconduct in processing emergency calls. The statute says that the entities in those cases, quote, shall be immune. It does not say governmental immunity, it just says shall be immune. This immunity is wholly separate from governmental immunity. It does not in any way remove or alter the doctrine of governmental immunity and does not even mention governmental immunity. The Governmental Tort Liability Act provides in Section 2920-201 that all governmental entities are immune, except as provided in this chapter, Title 29, Section 20. The statute also says any claim for damages must be brought in strict compliance with the terms of this chapter, Title 29, Chapter 20. The IP immunity statute, 786-320, is in a different title and a different chapter of the Tennessee Code, and it just does not affect governmental immunity. It also does not create a new cause of action, nor does it claim to. It just describes the circumstances in which the internet protocol immunity is removed.
All right, so it does remove immunity, at least under the circumstances set forth in the statute.
It removes the IP immunity, but it does not remove governmental immunity. It's our position that those are two separate immunities.
So what does it do?
It provides an immunity for the second layer of immunity for entities that are involved in internet protocol dispatching.
What does the removal of the, as you say, the IP immunity? Is it still?
It would just mean that the secondary layer of immunity is removed. The first layer of governmental immunity would remain in place.
So it means nothing?
It would mean nothing. Well, it would mean that if there were no governmental immunity and I was relying upon that statute, then it would mean something.
There is governmental immunity by the statute. Say, it's your position that that statute, which says it removes immunity, really has absolutely no effect because the governmental immunity is still in place.
Exactly. Yes.
I wonder what the legislature was doing with that statute then.
Well, if the statute
that's not a fair question. I apologize.
I struggled with that as well, Your Honor, to be honest. It looks like they were trying to enact a broad scheme that would encourage the use of this new technology, and they were trying to give everyone immunity for using it. And it really does not, in my opinion, and in our position, it does not affect at all governmental immunity, which is a whole different section of the code and a whole different immunity. The wording of it is, it could be more clear, but it certainly does not in any way have anything to do with governmental immunity. Furthermore, if the statute is strictly construed as statutes in derogation of the common law must be, it only applies to claims arising from processing emergency calls. That term is not defined, but it would be our position that that would not have anything to do with the dispatching of services after the call is completed. So it's our position that this case remains barred by the doctrine of governmental immunity, that Section 786-320 is not relevant and does not create a cause of action. So that leaves us with the public duty doctrine. This court found in its first opinion when we were here the last time that the duties owed were owed to the public at large and not just to the decedent. And plaintiff is relying only upon the third exception from the Ezell case, which is a cause of action involving intent, malice, or reckless misconduct. And as I stated earlier, it's our position that reckless misconduct is a wholly separate type of conduct than negligence or gross negligence. And that the Supreme Court has told us that claims for reckless misconduct may not proceed under the Governmental Tort Liability Act as to the entities themselves, because that immunity is not removed for reckless misconduct in the first place. So it is our position that the trial court got it right, and I ask this court to affirm the trial court's rulings in all respects.
Thank you.
Good morning, Your Honors. I'm Jeff Ward, representing Hawkins County and Hawkins County Emergency Management Agency. Frankly, I came here this morning thinking I didn't have anything to argue, that the Tennessee Supreme Court had already decided the issue pretty clearly with respect to Hawkins County. Justice Sweeney, I think your question to Appellant's Counsel was the correct question of what basis is there to proceed as to Hawkins County at this point, and our position would be there is none. The Tennessee Supreme Court has already decided that recklessness is not something that could be pursued against Hawkins County, the governmental entity, and then the only basis would be a negligence claim, which the public duty doctrine bars because there's no other exception that has been raised. So to the extent that Appellant's Counsel is now trying to say there's still some basis for this to proceed against Hawkins County, there hasn't been any other exception raised, pled, any claim that some other exception applies is waived at this point. And so the recklessness exception just simply cannot get them where they want to go as to Hawkins County. I believe that issue has been pretty clearly decided by the Tennessee Supreme Court. So our position from the standpoint of Hawkins County, to the extent that any issue relating to ordinary negligence was actually preserved, it still doesn't get the appellant past the public duty doctrine based upon the current ruling. To the extent that the Appellant's Counsel has suggested the public duty doctrine should be reconsidered in its application, which Justice Kirby did raise a question mark as to that. That's not before this court. It hadn't been preserved, and Justice Kirby specifically noted that it was not an issue raised or preserved, which is why the Tennessee Supreme Court declined to examine that. So from our standpoint, Hawkins County's standpoint, we'd submit that all issues related to Hawkins County and Hawkins County EMA have been decided at this point, and there is nothing else for this court to have to rule on. Does Your Honor have any questions for me?
No.
Thank you.
Here from the appellant rebuttal. And let me say, it was also an unfair question of me to ask you as to the other defendants. So I understand who you're representing, so I apologize for that.
With regard to Hawkins County, and again, based on the assertions and allegations made in our complaint, and it is possible at this juncture in the proceedings, if we're accepting those as true, that the negligent failure to train allows us to move forward under the GTLA. And also that, again, the deputy could be found to have engaged in reckless conduct and failing to take any action for approximately 30 minutes to close Highway 70. I would argue to this court that does allow us at this stage in the proceedings to proceed forward against Hawkins County and Hawkins County EMA. And I would ask the court to consider that. Again, we should not, and it is not justice to make us and make all plaintiffs try to thread some needle in this maneuvering between the GTLA and the public duty doctrine. And I think the scenario that I've laid out where there's negligent training that leads to reckless conduct is, again, absolutely plausible and is what we have asserted occurred in this case. With regard to the Emergency Communication District 911 and Statute 786-320 and D1, if you look at that section, it does not mention any type of IP immunity. That is not a creature of that statute. It says in section D1, emergency communication districts shall be immune from suit or liability for civil claims arising from the actions or omissions of emergency communications district personnel in processing emergency calls, except that claims for recklessness or intentional misconduct in processing emergency calls shall be permitted. So again, that's not referencing any type of separate IP immunity. This is just referencing the immunity of emergency communication districts. And clearly that sets forth the process to remove their immunity in that statute. And with regard to this distinction between gross negligence and recklessness, I think if this court reviews the Tennessee Supreme Court's opinion, it's pretty clear the distinction that the court made was between negligence, again, requiring, an awareness, some proof of the subjective state of mind for both gross negligence and recklessness. And I think throughout the Supreme Court's opinion, if you look at that, they've really used gross negligence and recklessness synonymously together when they've quoted it. In some, Tennessee courts have consistently defined gross negligence and recklessness in a matter distinct from ordinary negligence. So again, I don't think there's that distinction that counsel would like to place between gross negligence and recklessness. I think our Supreme Court's made it clear they made the distinction between simple negligence and gross negligence. Any other questions?
I hear none.
Thank you very much.
Our thanks to counsel, all counsel, both sides. We thank you for your oral argument this morning and for your brief. And everyone have a good drive back.